Okay, so we have a question that I wanted to answer from our question submissions. So, this question is about how an estate gets divided in a blended family. So, a wife has 3 children from a prior marriage, the husband has 1 child from a previous marriage, and they have 1 child together. So if the wife dies first, does everything go to the husband? And then when he dies, how would his estate be divided? This is assuming that there are no wills, and none of the property is already titled in the children's names. So the couple does have a child together. So here's how that is actually going to play out. And this is a common misconception that if you die without a will, your spouse gets everything. That is not the law in Tennessee. Now, a lot of times what we see with longtime married couples is that they've already combined everything. Their house is joint, their bank accounts are joint. Maybe they own the cars jointly, but basically, when the first spouse dies, everything already belongs to the surviving spouse by operation of law without probate, outside of how anything passed under the will, through the means of what we call non-probate assets. So obviously, if the family has everything listed together in the names of both the husband and the wife dies first, then everything would go to the husband. But if this is a couple who, and oftentimes blended families do, keep their finances separate, then what we are looking at is the husband would get between 1/3 and 1/2 of the estate. So if you only have 1 child, your child gets half, your spouse gets half. If you have more than 1 child, your spouse is entitled to 1/3 of your estate, and your children are entitled to the remaining 2/3. Now, there are some other claims that a spouse can make, but just for the sake of clarity, that is basically the rule. 1/3 to the spouse, and 2/3 to children if there are 2 or more children. And then this question is assuming that everything goes to the husband. Now, if everything goes to the husband, let's say that the wife does have a will, then everything goes to the husband, according to her wishes. And then when the husband dies, if he does not have a will, then everything is going to go and pass to his children. So she has 3 children from a prior relationship. Those children are basically going to be written out of the plan, because the plan in this case is written by the state of Tennessee. And so those children would not inherit anything from the man that is not their father. Now, sometimes we see this where children are adopted by a step-parent, or the step-parent has specifically named them in a will, and in those cases, they do inherit. But that's not the standard, and that's definitely not the law. So if the wife or the husband has previous children and then they leave everything to their spouse, then the spouse's children will inherit and their children will not if they die first. So that is the answer to that question. So if you die without a will, your spouse gets at least a third up to 1/2 of your estate that is not titled jointly. And then when your spouse dies, if they do not have a will, then whatever assets they have that would be within probate are going to pass to only their children. So this is why it's so important to do estate planning if you have a blended family, because, many times that is not the outcome that would be desired by the family. This is definitely something to talk to your spouse about before you get married. If you are in a relationship where, one or both of you have children from a previous relationship, and you want to protect those children, that can be accomplished with a prenuptial agreement. That can be accomplished through thorough estate planning, but you want to make sure that you have an estate plan and that it is designed to work. I hope that was helpful. If you have any questions, we will put the link to the question submission form on this video.